Hello again, FinTech fans. Welcome to part 2 of the Open Banking Rule story, or as it's now called, the Personal Financial Data Rights Rule, or PFDR. I believe it was George Carlin who pointed out the more syllables, the more BS they're trying to sell you, so let's get into it. As I mentioned in my first video on this subject, linked below, the freshly neutered Consumer Financial Protection Bureau, or CFPB, has launched a new advance notice of proposed rulemaking to fix the allegedly broken PFDR rule. This document, also linked below, was issued on August 22, 2025. Just for some brief context, a notice of proposed rulemaking is the process that a federal agency follows under the Administrative Procedure Act, or APA, that announces the agency's intention to create a new rule, or, as is the case here, change an existing one. A notice lays out the agency's position on an issue and poses a number of questions to the public. The public usually ends up being a group of trade associations and different actors who will be affected by the rule, although technically anyone is welcome to participate. The public usually has between 30 to 60 days to submit this feedback, which period is often extended. The agency considers the feedback and subsequently publishes the new or adjusted rule in the Federal Register. The published version typically addresses the feedback the agency received and lays out the agency's justifications for adopting or rejecting different positions. So with that in mind, what did the CFPB have to say about the PFDR this time? Well, right out of the gate, it was clear to see that attitudes towards open banking have changed around here over the last 6 months or so. The CFPB stated that the rule as it stands is quite sparse as to 5 important issues. 1, who may receive data on a consumer's behalf. 2, how the cost of providing that data should be handled. 3, the potential negative consequences to the consumer in the form of data breaches. 4, the potential negative consequences to the consumer's privacy. And 5th, the potential benefits of the rule in terms of market competition. After breaking down the main parts of the rule, the CFPB launched into its questions. As to question number 1, who may receive the data on the consumer's behalf? The agency pondered whether the rule requires that third parties like Plaid bear a fiduciary duty to the consumer. Simply put, a fiduciary duty is a heightened legal standard that says you must act in your customer's best interests over your own. Professions that typically owe this heightened duty include attorneys, trustees, and some types of financial advisors. Basically, the CFPB was asking for clarification as to whether Congress's intent was to limit data sharing only to those that bear this responsibility. Second, the issue of costs. Here the CFPB posed the question, does the PFDR's prohibition on fees represent the best reading of the statute? Given that the rule kind of says what it says, this question seems a bit disingenuous. In any case, assuming that the answer is no, the agency then went on to ask what might be reasonable estimates for how much it costs to provide this data through APIs. The CFPB then sneaked in a little assumption. They stated that a bank's obligation to pay for data access was actually due to an omission in the original rule rather than forming a central part of the rule as intended. Put another way, they're saying, gosh, we just forgot to say that grandma needs to share the cost, rather than, yes, the banks are supposed to make this data available. Next up, cybersecurity. This section has a special place in my heart since I am all in favor of everyone paying more attention to preventing hacks. The CFPB ran down the rule's original standards for how data aggregators and others need to protect consumer data, citing the standards in the Gramm-Leach-Bliley Act and others. The agency posed questions regarding whether the rule adequately protects consumer data, both while at the covered entity and otherwise, and again asked what it all should cost. Third, the privacy issues. The agency correctly pointed out that a person's financial history is among the most sensitive data anyone can collect. They also highlighted that it's a problem when consumers sign off on third-party access to this data without really knowing what they're getting into. They again brought up the question of whether data aggregators should have a fiduciary duty to consumers and whether that might help address these privacy concerns. Now, I agree with the way the agency framed the problem, but I find their renewed interest in data privacy a bit odd. See, the CFPB issued a data privacy rule back in 2024 under Director Chopra, link below, that would have reined in data brokers. They changed their tune on that one as well under new Director Russell Vought in 2025, removing a key constraint on some of the most notorious misuses of private information out there. Now, under the PFDR, suddenly this is important again? Okay. The CFPB wrapped up the notice by extending the compliance due dates for the rule's implementation. The rule's effectiveness is delayed anyway due to litigation and some other thorny issues under the APA, but I won't get into those in this video. So, What do we make of this new notice of proposed rulemaking? Well, if you've made it this far, and I appreciate if you have, you can probably tell I'm a bit skeptical of the CFPB's assumptions and approach relative to open banking. First, like I told you in the first video, cost sharing between covered entities, the consumer, and data aggregators is pretty much a given at this point. Second, this issue of whether data aggregators should be fiduciaries is an interesting point. On one hand, it would be great if companies like Plaid owed such a duty to their customers, and I think it would definitely encourage them to carefully protect data accessed through APIs. That said, being a fiduciary is no walk in the park. A fiduciary has a lot more liability to the customer than someone who is not. One data breach and millions of people could have a cause of action against the aggregator. Insurance rates go up, operating costs go up, legal fees go up. Is this talk about imposing a fiduciary duty genuinely motivated by a concern for consumer protection? Or is it a way to burden aggregators so much that they just exit the market? Also, the banks holding the data in the first place are not fiduciaries in this capacity. So if we're all in this together, why should the data aggregators be? I'd love to know your thoughts on any of the things we've discussed today, so please feel free to leave me a comment or two. So that's it for the look into the Personal Financial Data Rights Rule. I'm Ari Good, blockchain lawyer. Please contact me with any questions or if I can help. Thank you.